Dear audience, good morning, everyone, everywhere. Welcome to another episode of Advantere Talks, organized by the Master in Talent Management of Advantere School of Management. Let me introduce myself. I am Pedro Cesar Martinez, the Director of the Master in Talent Management of Advantere School of Management. As you may aware, Advantere is a management school with a unique focus on education through the lenses of social justice and sustainability. Advantere School of Management commenced operations in 2022. Since our inception, we have been dedicated to prepare the best students for a world that is constantly evolving. This dynamic environment requires the adoption of innovative solutions to address new challenges. We are committed to equip our students with the skills and knowledge needed to thrive in this ever-changing landscape. We were founded by Pontifical Comillas University and the State University, and we have established a strategic academic partnership with Georgetown University. Our founding fathers and this partnership guide Advantage's academic development and foster excellent relations with leading companies that share our philosophy. This master program, the Master in Talent Management, continues the outstanding tradition of postgraduate human resources education at Universidad Pontificia Comillas. Program in human resources in Spain, with a legacy spanning over more than 35 cohorts. This program boasts a network of over 4,000 alumni who are contributed to an excellent in some of the most prominent Spanish companies. We focus on adding solutions and maximizing the common good, aiming to impact society through social justice and sustainability inspired by the Society of Jesus. We engage in project-based learning, working collaboratively in teams to analyze information from decision-making. We embrace a flipped classroom approach, gaining foundational content through videos, postcards, and other resources while taking responsibility for your own learning. We benefit from real-world experience with professors who blend academic rigor with business expertise, both for industry and consulting. And as I mentioned earlier, today we are delving into the crucial topic of labor law and HR. Fortunately, especially for me, we have a brilliant expert with us. I'd like to introduce Carlos Saldaña. Good morning, Carlos. How are you?
Hi, Pedro. How are you doing? Okay, nice to be with you here.
First of all, thank you so much for me here with us and with share with our audience your brilliant knowledge and your brilliant background about labor law. Let's get
Thank you.
started. I would like to share with you some questions related to our topics.
hmm
First of all, Carlos, what are the fundamental principles that underlie labor law and how have they evolved over time?
Well, yeah, well, this is a very long question, but I will try
Yeah.
to summarize because we have to talk about a lot of things. That I think the labor law, which is at the end the framework governing the employment relations between employers and employees and trade unions and so on, have six, seven main principles that they have evolving with the years, and very linked to economical situation and political situation and the legislation. But basically, principles of freedom of association, to ensure workers' right to be forming trade unions and to engage collective bargaining agreements and so on. The right to collective bargaining, to the right to collective negotiations, and to reach agreement with employers for a specific working matters and so on. The protection of working rights, um, that protects the employees' rights and conditions. The regulation of the employment contracts, as well as some health and safety regulations, which are very focused on health and safety or labor risk prevention. Social security and unemployment relations, which is another part of the legal framework of this kind of relations. Another is globalization of the international labor standards. At the end, this kind of globalization is evolving a little, evolving a lot, and it affects the rest of the employment, employment regulations.
Thank you so much, Carlos. Maybe the second one will be shorter and easier for you.
Yeah.
Can you explain a more precise question? The key distinctions between individual and collective labor law?
Yeah. Well, individual and collective labor law are the two branches of the employment law, but very different. And I will try to summarize, the main focus, the scope, the key features, and how it's enforceable. Individual labor law, the focus is the individual relation between employees and employers. Uh, Specific details, employment contracts, and individual topics as an employee, as a person. Um, and the collective labor law, it's over the collective topics, collective questions, the personnel, not only an individual. So the scope is in case of individual labor law is employment contracts, your contract, my contract. So it's an individual and the relation with the company, and the collective is collective bargaining agreement, collective negotiations, and working rights which are regulated in this kind of collective regulations. Um, the the main features is at the end the individual labor law is regulating my rights, while collective labor law is regulating collective rights. And the enforcement in individual labor law, there is individual negotiations, but at the end, some of the controversial will be decided in the court of justice. And with collective labor law, at the end, there's a lot of collective negotiations, bargaining agreement, and a lot of mediation and arbitration. So it's a little bit different, but at the end, it's individual, me and the company, and collective, my representatives, my legal representative, or trade unions, worker representatives, and the company and the employer, which could be also employers associations and so on.
Thank you so much, Carlos. I suppose the third one will be very relevant and interesting for our audience, no? Because it's a very precise question. In what ways does labor law protect the rights of employees, particularly in terms of working hours, wages, and even working conditions?
Well, you know that labor law is regulating, and the labor law legislation is a regulation, very wide regulation of all the working conditions. But basically, working hours, working conditions, and wages. I mean, the regulations is, for example, working hours is limited or limits of working hours. I mean, you cannot work more than X hours, and the number of hours you can work, the rest periods. I mean, for example, in Spain, every 6 periods, if you have a break, and so on. And the regulations of specific conditions for working, specific working periods. For example, night workers, or workers who are working on shift, production shifts, and so on. So at the end, it's working time, when it's considered to normal, to work as a normal time, what is an overtime, which is the maximum limit for overtime, how to be compensated, and so on. Regarding wages, there were regulation, and a labor law, and not, and I don't want to specific country, because I think we are talking about global level law topics, and minimum wage. I mean, you have to earn a minimum wage. I don't care if it's in one country or another. If there's a minimum wage, uh, which will be the payments you have to receive in case of overtime, in case of specific working conditions, in case of holidays, and so on, and all the legislation linked to equal pay protections, which is now is bigger, is increasing, and there is a very big legislation, which mainly international legislation, which is coming to the countries. And considering working conditions, I think it's important, health and safety regulations. I mean, okay, you have to be safe at your working place. There is a lot of regulations of health and safety. Protection against discrimination and harassment. I mean, this. I mean, it's getting bigger and bigger, and it's really important. I mean, it's not only you have to be safe, and the company has to prevent labor risk, but only the protection against discrimination and harassment, and the protection of the employment, the employee rights. I mean, you have to have the right of to association, to give your opinion, to a lot of things. So basically, in terms of wages, in terms of working hours, in terms of employment conditions, they are the main protections. Of course, it depended on the a lot of global conditions, and it's evolved as well. But there's the main topics I will highlight.
Thank you so much, Carlos, for your response. Unfortunately, some conflicts happen. A
Mm.
company is a group of
Sometimes,
people.
sometimes.
Sometimes, no? A company is a group of people, and it's composed by different people from different profiles, with different skills, from different origins. How are labor disputes typically resolved, and what mechanisms exist
Mhm.
for mediation or arbitration?
Well, yeah, sometimes conflicts, and where level or it's or employment matters are very dynamic, which is daily life. So at the end, some conflicts happen, and I think that the most typical ways of resolution of the conflicts, uh, I I would say maybe four or five. First of all is negotiation. Level O has a lot of negotiations, informal discussions. If I want to reach an agreement with an employee of a trade union or whatever, there is always room for negotiation, and but it's informal. And the other negotiation, which is more formal, is collective bargaining agreements, and so on, which is the specific requirements for those agreements to be enforced and so on. The second one would be mediation. Third party mediation, voluntary process, a conciliation act, which is, a third party tries to put you in common and to try to advise you to reach an agreement. But it's voluntary or voluntary to reach an agreement or not. So at the end, like a conciliation act and so on, it is mediation. The third one will be arbitration. I mean, okay, I mean, both parties are decide that to go in front of an arbitration process. So at the end, the resolution of the arbitration process will be binding for both parties. So it is voluntary, but once I go, I have to accept and to accept the decision. And the third one is litigation, which is okay, we don't reach an agreement, no way for discussions, there is no result for conciliation. We don't going to go to an arbitration, or we cannot go because legislation something is different in some countries, and we go to court. And at the end, there is a third party deciding, which it will be a judge. And of course, it will be enforceable, but it's another topic, procedural law, and there is appeals and resolutions and different courts and tribunals. But I think this is the most typical from the easiest way, which is discussion, which is our daily life, to litigation.
Our students, Carlos, as you know, come
Hmm.
from different countries, from
Hmm.
diverse regions and all over the world.
Hmm.
Um, and unfortunately, we work with companies from everywhere. No,
Hmm.
are there any international standards or conventions that influence labor law on a global scale?
Yeah, a lot. And when we are, talking with the students at at the master, and the idea is to have we live in a global world. So at the end, we have a lot of global regulations with impact employment topics. For example, the International Labor Organization, they have a lot of conventions and recommendations, more than 190 conventions, more than 200 recommendations. So there's a lot of recommendations with a lot of topics. So there is a declaration of fundamental principles and rights in the work, which affects national legislation. United Nations also, they have the United Nations Universal Declaration of of Human Rights. We have of course working with nations and working rights. There is a United Nations Sustainable Goals, which the for example decent work and economic economy to promote decent sustainable and inclusive working conditions as well. And there is a lot of other regional standards and convention. For example, in Europe there is a lot of directives, a lot of court decisions from the European Court of Justice, that and the European legislation, which in sometimes are influenced by international labor organizations, and United Nations Universal Declarations of Human Rights, that have to be implemented in the country. So at the end, there are local laws that are, implementation of international regulations. So, and it affects depending on the country. So that's the point.
Thank you, Carlos. And finally, the last but not least question, because I'm going to suggest you to speak about probably the most relevant topic nowadays, because everybody are talking about technology and how technology is affecting or is impacting our lives. No, how is technology influencing labor law, especially with regards to remote work, to working from home,
Hmm.
and digital platforms?
Yeah. Well, I think that technology makes life changes, world's changing, and labor law has to evolve and to change with our daily life, with reality. I would say that, for example, in remote work, labor law is changing. Why? Because we need flexible work arrangement. If you want to work on remote, you want to do home office, and that you need flexible work arrangement, and you need flexible negotiation with trade unions. So this is again the distinction between individual rights and collective rights. So and you need that the labor law will adapt and accommodate to the new times, and to new expectation for the employees. You need health and safety regulations for remote and remote work, and you need data privacy and security for all the data that are flowing around, and employees and so on. Regarding digital platforms, I think it is the new reality, or one of the new realities. And the gig economy and the work platform, they need on specific regulations to be adapted to the employers and employees needs. The worker classification, how this worker will be considered, and to fair labor standards. I mean, to digital platforms use algorithms, and how to manage the work, and how to address about transparency. How are those mathematical solutions and implemented. And of course, there is a lot of topic which is the remote surveillance and monitoring. I mean, technology is an advance, but of course you can monitor what are you doing, what your employees are doing, where they are, and so on. And it has to be regulated. So the employment regulation has to be added to that. And of course there is around of this is the work and life balance. I mean, uh, at the end, if I work from home, it's a flexibility. So labor law will need to be adapted. There's a work and life balance, and of course labor law will have to be adapted to the needs of the employees and expectations and so on. So at the end, uh, coming back to the first question, I mean, principles are evolving, and are evolving because the economy and the situation and the globalization is changing, and law is alive, and employment law is alive as well, because persons' expectations, needs are changing. So we need to adapt it.
Thank you so much, sincerely, Carlos, for being on here and sharing your brilliant insights on labor law
A
topic.
pleasure for me.
Yeah, I would like to highlight how distinguish the individual and collective rights, and how labor laws are regulating how society is evolving.
Hmm.
Maybe the one of the best advice is trying to have a good lawyer close to you, no, in order to
Yeah,
avoid problems for the
yeah,
future.
yeah. You have to be flexible, innovative, creative,
Yeah.
and yeah, yeah.
Well, the audience, thank you so much for joining us in this another episode of Advantere Talks. Your participation is unbelievable. Stay tuned for our next month sessions where we unravel the intricacies of talent management, a strategic approach crucial for every organization. Ever wonder how top companies attract, develop, and retain their best talent? Join us as we explore the secrets behind effective talent management strategies. See you next month. Have a good day.
Bye bye.